On August 2, 1993, 13-year-old Eric M. Smith took the life of Derek Joseph Roby in Savona, New York. Roby was on his way to a local park when Smith lured him into the woods and assaulted him. Roby lost his life due to asphyxiation and severe head injuries.
I remember him coming up to me in the kitchen. He was really upset. He was crunching his fists and shaking. He said, "Dad, I need help. I feel like I want to hurt somebody." And I said, "Hold it. Let me explain something to you. When I got angry, when I was at your age, the best thing to do was I grabbed the bag in our barn and I just started beating on it."
Smith was tried as an adult and convicted of second-degree murder in 1994. He was sentenced to 9 years to life in prison. After serving 27 years, he was granted parole in October 2021 and released in February 2022. Smith had a tough childhood, where he was bullied for his red hair, glasses, large ears, and freckles. He was also reportedly a victim of domestic abuse. His mother, Tammy, took medication for epilepsy during pregnancy, which is known to sometimes cause birth defects.
I had a problem with anger. I knew I do. I might be, just happy-go-lucky now, and someone get me mad.
During the trial, Smith's defense attorney argued that he suffered from intermittent explosive disorder, a condition that causes sudden violent outbursts. However, a prosecution expert testified that this disorder is uncommon in 13-year-olds. Despite extensive medical testing, no clear reason for Smith's violent behavior was found. Over time, Smith expressed remorse for his actions and apologized to the Roby family. He suggested that the bullying he endured and the abuse he faced, which led him to shut down emotionally, may have played a role in his violent behavior. On the evening of December 11, 2019, tragedy struck in Morningside Park, New York City. Tessa Majors, an 18-year-old first-year student at Barnard College, was attacked and lost her life. Tessa, who loved journalism, music, and activism, had a bright future ahead of her. She was in the park that night, focused on her phone, unaware of the danger approaching. 3 young attackers, 16-year-old Rashawn Weaver, 13-year-old Zaire Davis, and 14-year-old Luciano Lewis, had planned to rob people in the park, but the situation quickly turned violent. Weaver was the first to act, kicking Tessa in the back and demanding money, yelling, "Give me your money, run your pockets!" Weaver then repeatedly attacked Tessa in the chest, sending feathers from her coat into the air. Witnesses and court testimony described the brutal nature of the attack. Lewis, who was part of the group, later claimed he didn't realize how badly Tessa had been hurt until the next day when he saw her picture in the news. During the attack, Lewis had Tessa in a headlock while Weaver continued attacking her. Afterward, Weaver bragged about being bitten during the struggle, showing a disturbing lack of concern for what had happened. The attack was violent and chaotic, with no regard for Tessa's life.
We're dealing with a 14-year-old, and what I want to say as the district attorney is that we will be very careful to safeguard all the rights that he has as we go forward with this case. We are committed, our office, as I know the NYPD is, in fairness in all our cases.
Tessa Majors had been attacked, and security cameras captured her final moments as she struggled up the stairs of Morningside Park before collapsing near a guard station. After the attack, the legal system acted quickly. Zaire Davis, the youngest of the attackers, was tried as a juvenile. He pleaded guilty to first-degree robbery and received an 18-month detention sentence. Luciano Lewis, also involved in the attack, pleaded guilty to second-degree murder and first-degree robbery and was sentenced to 9 years to life in prison. During his sentencing, despite the mask on his face, there was a clear look of regret in his eyes, showing he realized the seriousness of his actions. Rashawn Weaver, who had already been involved in another violent robbery and played a major role in Tessa's murder, pleaded guilty to second-degree murder, first-degree robbery, and second-degree robbery, receiving a sentence of 14 years to life in prison. Before Tessa's demise, Morningside Park had seen a rise in robberies, often involving young suspects, and this tragic event highlighted the growing issue of youth violence in the area. In a Cleveland courtroom, chaos erupted when James Sparks Henderson was sentenced to 5 consecutive life sentences for the 2014 incident that claimed the lives of 5 people, including a pregnant woman.
Mr. Sparks Henderson, I'm going to ask you, how do you plead to count 1 as amended, the aggravated murder of Lemon S. Bryant on November 21st, 2014, an unclassified felony requiring a sentence of life imprisonment.
It all began on November 21st, 2014, when 21-year-old James Sparks Henderson went on a violent spree, ending the lives of 60-year-old Lemon Bryant, 17-year-old Shaylona Williams, and 18-year-old Jario Taylor inside a home on East 93rd Street. The violence escalated when 41-year-old Sharita Johnson pulled into the driveway with her daughter. Sparks Henderson fired at Johnson, who was pregnant, resulting in her loss of life, while her daughter was injured but managed to survive.
Your Honor, before we proceed to victim impact statements, the state would like to outline the strengths of the evidence that led to this plea.
After the incidents, Sparks Henderson was arrested in May 2015 at a McDonald's, still carrying the weapon used in the crime. His capture came after a lengthy investigation, and what made the crime even more shocking was that he had taken photos of the victims after ending their lives. The atmosphere in the courtroom during his sentencing was intense and emotional as family members confronted him. Delray Johnson, Sharita Johnson's uncle, shouted at Sparks Henderson to wipe that smirk off your face before attempting to charge at him. But deputies quickly intervened. The outburst caused a brief pause while security calmed the room. Despite the emotional pleas from the grieving families, Sparks Henderson remained detached, occasionally smirking. He had agreed to a plea deal just days before his trial, confessing to 5 counts of aggravated murder and 2 counts of attempted murder, sparing him from the death penalty.
You are so lucky guys got this off my chest. And I'm thankful because you made my life change. You as a person have changed me. Because I've been in this penitentiary. I've been in the penitentiary 4 times. I'd have kicked this podium over and everybody out here. But now no more, it's over with.
The decision not to pursue the death penalty for Sparks Henderson was influenced by his mental health. His defense argued that he was mentally disabled, citing his IQ of 73 and school records that showed cognitive impairments. This decision aligned with a U.S. Supreme Court ruling that prohibits the execution of individuals with intellectual disabilities. This played a key role in shaping the case. Former Cuyahoga County prosecutor Timothy McGinty initially decided to remove the death penalty option after Sparks Henderson confessed, believing that his immediate admission of guilt warranted some leniency. Although McGinty's successor, Michael O'Malley, disagreed with the decision, he chose to respect the deal already made.
On count 3, the aggravated murder of Jario Taylor, you are ordered to serve a sentence of life imprisonment without the possibility.
In court, Judge John O'Donnell sentenced Sparks Henderson to 5 life terms without the possibility of parole, guaranteeing that he will remain in prison for the rest of his life. Tamikia Johnson, a California Highway Patrol officer, found herself in a tragic situation in February 2009 when she fired at her husband, Marcus Lemons, on a freeway exit ramp. After the incident, Tamikia drove to her parents' house with Marcus's body in the front seat. When questioned, she gave a detailed account of what happened. She said they had started the night at TG Ysprai at Fridays, but an argument broke out. Tamikia claimed she took the car keys and started driving home, trying to ignore Marcus. However, Marcus became angry when she ignored him and grabbed her neck. Tamikia said she pulled over, hoping to calm the situation, but the struggle continued when Marcus took the keys from the ignition and reached for her purse. Believing he was going for her weapon, she got the weapon and fired at him in self-defense. However, after investigating, detectives didn't believe her story and suspected it was premeditated murder. 2 years after Marcus's demise, Tamikia was arrested and charged with murder. She pleaded not guilty and was held on a $2 million bail while awaiting trial. Due to the arrest, she was placed on unpaid administrative leave from her job as a highway patrol officer. During the trial, her defense team argued that she was a victim of domestic violence, not a cold-blooded murderer. But the prosecution countered this, presenting evidence that Tamikia had a history of aggressive behavior and excessive drinking. They also described Marcus as a kind and peaceful person. Tamikia testified in her defense, but it wasn't enough to convince the jury. She was found guilty of first-degree murder and sentenced to 50 years to life in prison. On January 25, 2010, 13-year-old Kashan Man took the life of his mother's boyfriend, Jermel Stokes, in their home in Kentwood, Grand Rapids, Michigan. Man used Stokes' weapon to fire at him while Stokes was sitting at a laptop.
It was his only way out. He didn't know no other way out. He was a young 13-year-old kid. He just turned 13. That's his only, he didn't know anything else to do.
Man was charged with second-degree murder and pleaded guilty in June 2010. He was sentenced to stay at the Muskegon River Youth Home, a secure juvenile facility, until he turns 21. After that, a judge will determine whether he should be released or transferred to an adult prison. During the case, allegations of domestic violence emerged. Man claimed that Stokes had abused him, his mother, and his 3 brothers by beating them with a paint stick and choking him. However, Stokes' family denied these claims.
Any abuse, didn't nobody know it. And that kind of secret do not stay in a closet like that.
This created a significant misunderstanding in court between Man and the victim's family. However, while at the youth home, Man made substantial progress by addressing his anger, developing coping skills, and participating in educational classes and counseling sessions. In December 2017, when Man turned 21, Judge Daniel Zetas decided to release him, recognizing his successful completion of various programs and behavioral improvements. Upon his release, Man also met with Stokes' father, who supported his goal of leading a productive life. This case comes from South Carolina in 2016 and involves 2 teens, Jacob Mozon, who was 17, and Drake Campbell, who was 18. They were charged with armed robbery, burglary, and murder. The 2 had broken into a home to steal items, but things went tragically wrong, resulting in the loss of a life. When their sentences were announced, both Jacob and Drake, along with their families, were seen crying in court.
Brings 17-year-old Jacob Muzon and 18-year-old Drake Campbell to tears.
The person that they're making him up.
One friend of Jacob said, "Jacob's my best friend. I know what he did was wrong. I completely understand that, but he's not a bad person. While this might be true, Jacob still made a terrible mistake by taking a life. You might feel some sympathy seeing them cry in court, but it's important to remember the severity of their actions and that someone lost their life because of it." Mario Guzman and Jose Guzman are present at the Jefferson Circuit Court in Louisville, Kentucky, awaiting trial for substance charges after being released on bond. Samantha Ayala, Mario's wife, is seated behind the defense table during the hearing. The prosecutors are seeking an increase in Mario's bond due to new charges, which include second-degree burglary, tampering with evidence, and possession of cannabis.
In your order, it specifically says no further violations of the law. He picked up new charges. He violated the law.
The prosecutor argues that these offenses violate Guzman's bond agreement. The defense team contends that the proposed increase in Guzman's bond from $5,000 to $155,000 is excessively high, stating that the defendant does not have the financial means to pay such a large amount, and emphasizing that the purpose of the bond is to ensure that someone appears in court. Judge Mary Shawn is prepared to announce her decision.
I agree. New charges obviously have been picked up. Current bond is not appropriate. It will be $5,000 full cash.
If Guzman fails to come up with the required amount, he will be incarcerated while awaiting trial. However, Guzman has other plans. His bailiff is prepared to escort him out, so he dashes frantically for the door. Samantha Guzman, Jose's wife, can be heard screaming as the deputy uses his taser, and Jose pleads with the judge to intervene.
Father's justice, Mom! Mom! Father's justice, Mom, now! Mom! Father's justice now, Mom! Sorry, ma'am. I'm choking.
Shut up!
No.
Samantha was so distressed and screaming that the officers had to put her in handcuffs. The deputies were able to remove Guzman from the courtroom, although they sustained some minor bruises while trying to subdue him. The judge then charged Guzman with an additional 3 counts of attempted assault and criminal mischief, raising his bond by another $2,500, which brought the total to $77,500. These 6 men, called the Goon Squad, shocked many with the name they chose, considering they were police officers. The terrible and upsetting crimes they committed are enough to make anyone angry.
5 former deputies and 1 police officer entered this home, no warrant, no evidence that anything was happening there. And they proceeded to torture these men for hours using food, at one point a sex toy, and threatening an execution.
On January 24, 2023, in Mississippi, a group of officers known as the Goon Squad, consisting of Brett McAlpin, Hunter Elward, Christian Dedman, Jeffrey Middleton, Daniel Opdyke, and Joshua Hartfield, carried out over an hour and a half of brutal torture on Michael Jenkins and Eddie Parker. The officers claimed to be responding to a report that Jenkins and Parker had entered the home of Christy Wally, Parker's childhood friend who was paralyzed. Parker, who was her caretaker, became their target. Without a warrant, the Goon Squad forcefully broke down the door, restrained Jenkins and Parker, and began a horrifying attack. Wally was in the hospital at the time. During the assault, the officers used slurs and insults while beating and torturing the 2 men. Before leaving, they planted a weapon and substances in the house, falsely accusing Jenkins of firing at them. They also took the house's security footage and threw it in a river to cover their tracks. The group later pleaded guilty to several felony charges, including deprivation of rights and obstruction of justice. Attorney Malik Shabazz called it one of the worst cases he had ever seen. Despite their guilty pleas in August 2022, the Goon Squad wasn't sentenced until March 2024. Each officer had a different reaction to their sentencing. Brett McAlpin, seen as the leader, was sentenced to over 27 years in prison and gave a shaky apology, which didn't console the victims. He was described as a tyrant who led the group's actions. Daniel Opdyke, who received 17 years, broke down in tears and apologized, but Jenkins left the courtroom during his speech. Opdyke tried to explain his actions by talking about his own abuse during his childhood. Hunter Elward, who fired at Jenkins, was sentenced to 20 years and expressed deep remorse. Jeffrey Middleton got 17.5 years for his part in the abuse and obstruction, while Joshua Hartfield, sentenced to 10 years, wept as he apologized for using a taser on the victims and attempting to destroy evidence. Hartfield wasn't part of the Rankin County Sheriff's Department, but joined the attack in hopes of getting hired there. Christian Dedman, who threatened to assault the victims and was seen as the most depraved, received the longest sentence of 40 years. Though he didn't directly address the victims, he said he could never forgive himself for what he had done. In a heartbreaking case from Toledo, Ohio, 16-year-old Joshua Coleman was sentenced to life in prison for taking the life of 15-year-old Deja Green. Deja had gone missing from her Toledo home over a year earlier, and Coleman, who had spent time with her and even stayed at her house occasionally, became the main suspect. The reasons behind Coleman's decision to turn on Deja remain unclear. Prosecutors revealed that Coleman fired at Deja in the back of the head in a central Toledo alley, resulting in her loss of life. Though Coleman never explained his motive, the court heard a disturbing sequence of events, with a key eyewitness identifying Coleman as the trigger man. He was arrested just days after Deja's body was found in an alley along Page Street. His case had been moved to adult court shortly before his arrest. Deja, who had occasionally run away from home, was reported missing by her family days before her body was discovered. This time, her disappearance caused heightened concern. In court, her mother, Tiaria Hill, gave an emotional impact statement describing Deja as a vibrant and social girl. She spoke of the immense grief her demise had caused their family, especially Deja's 2 younger sisters. Through tears, Miss Hill expressed her heartbreak and questioned why such a terrible fate had taken her daughter, while Coleman still had a future ahead of him.
Why would Joshua do this to her? She didn't deserve it. She was a social butterfly. She didn't deserve it.
Throughout the court proceedings, Joshua Coleman remained emotionless and silent, offering no explanation for why he took the life of Deja Green. His defense attorney called the case incredibly sad, highlighting that Coleman was only 15 at the time of the incident. Prosecutor Jennifer Donovan praised the bravery of the eyewitness who came forward, saying that without their testimony, justice might not have been possible. In a tragic twist, investigators revealed that Deja was the daughter of DeAndre Green, a homicide victim from 2010, though there was no connection between the 2 cases. This revelation only deepened the pain for Deja's family. Coleman pleaded guilty to murder, and as part of a plea deal, charges of felonious assault and additional weapon specifications were dropped. He remained cold during his sentencing, and when the judge asked if he wanted to say anything, Coleman simply replied, "No."
Tell the court why you did it.
Judge Michael Ging sentenced Joshua Coleman to life in prison with the possibility of parole after 15 years, though it did little to change the outcome. Coleman's conviction provided some sense of justice for Deja Green and her grieving family, but the deep pain of losing such a young life will continue long after the court case has ended.
Finally starting to show these youth that you can be charged as an adult and you can do grown people time. So at any point in time, you gotta think twice about what you're gonna do. I'm just glad my daughter got her justice.
Coleman will have a chance for parole in 2039, but the pain from this tragic act will stay with Deja's family for the rest of their lives. On November 18, 2021, 16-year-old Marquez Walker fatally attacked Jermaine Cools outside a chicken shop in South London, inflicting 7 wounds. Walker admitted to his acts, carrying a knife, and to another charge of seriously injuring a fellow inmate while in youth detention. In May 2023, he was sentenced to life in prison with a minimum of 19 years.
In any event, of course, you will be serving the life sentence which I will impose for the murder of Jermaine. I have concluded that the aggravating factors for the murder outweigh the mitigation, and that a minimum term of 19 years would have been appropriate in your case.
At the time of the incident, Walker was out on bail for carrying a large zombie knife and had a history of possessing dangerous weapons. He had been arrested multiple times for carrying knives and was well known for frequently being armed. Disturbing CCTV footage from the attack showed Walker calmly approaching Jermaine Cools and pulling a machete from his coat before repeatedly attacking him. Cools, who was unarmed and attempting to flee, tragically lost his life due to a wound to the chest. While in detention, a prison guard found rap lyrics written by Walker in which he described the incident without showing any remorse. Jermaine's mother, Lorraine Duty, called for stronger action against knife crime, criticizing the failure to address Walker's pattern of carrying knives. She emphasized that simply confiscating weapons is not enough to deter offenders. The victim's father also expressed dissatisfaction with the court's verdict.
My son can never come back, and you only get 19 years. Come on, man. That's a joke. You know? He's giving other youths the opportunity to go and do what they want to do, and they just get nothing out of it. You know? So I think that's a joke.
Despite offering an apology during his sentencing, Walker was sternly rebuked by the judge. When 16-year-old Erin Cathy was told by her parents that she could no longer see her boyfriend, she decided to seek revenge. She planned to have her entire family harmed while they slept. However, a mistake during the attack led to her eventual arrest.
Why are you here?
For the murders of my mother and 2 brothers.
You pled guilty because you are guilty, is that correct?
Yes, sir.
What did you do that made you part of this murder?
I knew about it and didn't say anything.
Let's go to Hopkins County Circuit Court, where Erin Cathy is about to be sentenced for her horrific crime. While the details vary, on March 1st, 2008, 18-year-old Charlie Wilkinson, his girlfriend Erin Cathy, and their accomplices, Charles Wade and his girlfriend, drove to the Cathy family home with the intent to harm Erin's family. According to Wilkinson, he told Erin he would have to take the lives of her brothers to eliminate any witnesses, to which she allegedly responded, "I don't care, just do what you gotta do." Wilkinson and Wade entered the house, heading to her parents' room, where they harmed the couple with a weapon while they slept. When Wilkinson's weapon jammed, Wade used a samurai-style sword to fatally attack Penny, nearly decapitating her.
I hear my wife screaming, saying, "Where's Terry? Where's Terry?" I would hear the voice of the killers. He told her, "Why don't you just die?" He put the sword that he had to her throat, and he rammed it in and he slit her.
The duo then went upstairs, where Erin Cathy's brothers, Tyler and Matthew, were hiding, and they took their lives as well.
My 13-year-old son, Matthew, he began to cry out, "No, Charlie, no, please don't do this. Why are you doing this?" And for the very first time, I realized Erin's boyfriend, Charlie, was the killer.
Wilkinson and Wade then searched the house for valuables and set it on fire. Unbeknownst to them, Terry Cathy miraculously regained consciousness as the flames spread and managed to crawl out of a window. He made his way to a nearby neighbor's house, where they called the police. Terry was rushed into emergency surgery and, once stable, told sheriff's deputies that Charlie Wilkinson was responsible for the acts. Authorities quickly tracked down Wilkinson and brought him in for questioning. They also located Erin Cathy at the trailer where she was staying, and she initially claimed she had been kidnapped. However, the truth soon came out. Erin had plotted to harm her family after her parents demanded she end her relationship with Wilkinson, whose online behavior raised red flags. Both Wilkinson and Wade told police that the acts were Erin's idea, although Erin continued to tell her grandparents she had nothing to do with her family's demise.
I didn't think that he would follow through with it. I would just ask him questions like, how would you do that? Instead of just saying, whoa, stop.
Wilkinson testified that he had suggested they run away together, but Erin Cathy insisted on having her family harmed. In the end, both were charged with capital murder. Wilkinson and Wade received life sentences without the possibility of parole, while Erin was also sentenced to life, but she will be eligible for parole after 40 years. Despite everything, Erin still claims she is innocent, and surprisingly, her father believes her. He has maintained a relationship with her to this day. On December 23, 2022, 18-year-old Kashan Adams Wright took the life of 19-year-old John Tay Hudson inside the Nordstrom store at the Mall of America in Bloomington, Minnesota. The incident occurred during a fight between two groups of teenagers, resulting in Hudson's loss of life and injuring a female shopper. In May 2024, Adams Wright was sentenced to over 30 years in prison, or 367 months, after pleading guilty to second-degree murder and second-degree assault in March 2024.
To the Custody Commissioner of Corrections for a period of 367 months. Against that sentence, you are entitled to credit for 524 days. Restitution is reserved for 45 days. $50 fine, $75 surcharge, and $3 law library fee to be taken from prison earnings.
During sentencing, Adams Wright apologized for his actions, attributing his behavior to the influence of video games, music, and movies.
I apologize for bringing pain and suffering to the victim family, also to the lady who got shot, and to the community. I was influenced by false friend movies, music, and video games, but I cannot take back my action. I truly apologize for my actions.
Judge Paul Scoggin sharply rebuked Adams Wright, pointing out his active role in the group that hunted down and took the life of the victim. The incident at the Mall of America triggered a lockdown and led to stricter security measures. It was one of 3 weapon-related incidents at the mall within a year. This is 18-year-old Victor Nathaniel Rivas, who is on trial for taking the life of 15-year-old Ethan Soto in Bexar County Court, Texas. On May 16th, 2022, around 3 p.m., Rivas allegedly fired at Ethan Soto after luring him from his home on the 2100 block of Allen Drive near Callahan Road on the northwest side of San Antonio. The day before, Soto had robbed Rivas of his THC cartridges, and Rivas's mother tried to make amends by paying Rivas for the stolen cartridges. She arranged to meet with Rivas to give him the money, but Rivas was focused on revenge. A few hours later, Rivas messaged a girl to set up a substance deal with Soto. The girl contacted Soto on Instagram, pretending to be interested in buying substances from him, and made plans to meet near his home. On May 16th at 2:55 p.m., she told Soto she was in the area, prompting him to leave his house to meet her. Unfortunately, the girl wasn't there, and Rivas ambushed Soto. Several rounds were fired at him, allegedly as retaliation for the earlier substance robbery. Authorities arrested Rivas in August 2022 and charged him with murder. During his court appearance, Rivas made a disturbing gesture towards Soto's family, who were also in the courtroom, leading to a violent confrontation. At least 4 members of Soto's family attacked Rivas, throwing punches at him. 2 court bailiffs had to step in to break up the fight, while the rest of Soto's family was escorted out of the courtroom. Reports indicated that Rivas sustained only minor injuries. After the incident, 2 adults and 2 minors were arrested and charged with assault and disorderly conduct in an open court. In April 2017, former Balch Springs police officer Roy Oliver fired at Jordan Edwards, an unarmed teenager, as he was leaving a party with his brothers and friends. Oliver claimed he fired at the car because he thought it was a threat to his partner, Officer Tyler Gross. However, Gross testified against Oliver, stating that he did not feel in danger and that there was no need to use his weapon. During the trial, body camera footage showed Gross talking to the party host inside when the sound of violence was heard outside. Both officers ran outside, and Gross approached the car containing Edwards and his brothers, which was slowly backing away from the house. Gross shouted for the driver, Vidal Allen, to stop, but the car continued to reverse. He shouted again and tapped the rear window with his pistol, accidentally breaking the glass. As the vehicle started moving forward, Oliver fired 5 rounds from behind the car, one of which struck Edwards in the back of the head, resulting in his loss of life. After more than 13 hours of deliberation, a Dallas County jury found Oliver guilty of murder, but not guilty of 2 aggravated assault charges. He was sentenced to 15 years in prison and fined $10,000.
We, the jury, having found the defendant Roy Oliver guilty of murder and having made a negative finding on the special issue of sudden passion, assess the defendant's punishment at imprisonment in the institutional division of the Texas Department of Criminal Justice for a term of 15 years and a fine of $10,000.
We are very satisfied with a guilty verdict. We believe that this is historic in the sense that we have not had a guilty verdict for the shooting of a police officer in active duty since 1973, I think, was the last time that happened in Dallas County.
This was a significant ruling because it's uncommon for police officers to be indicted and nearly unheard of for them to be convicted of murder in on-duty shootings. Next up is former Deputy Joshua Underwood, who is appearing for a bond hearing after being charged in connection with a standoff.
I find the solicitor's request for a cash or surety bond of $50,000 to be reasonable accordingly. I'm going to impose that cash or bond for your release.
I find it absurd that you haven't even obtained any information from me based off the solicitor. You're going to believe everything that he says.
Okay.
And you're going to go ahead and set a surety bond on me on a misdemeanor.
Okay. Are you finished? Okay. If you'll hear me out, please. Thank you. Additionally, I'm going to place a requirement for a GPS monitor prior to your release on bond. I'm going to restrain or restrict your contact with your domestic partner or the mother of your child, whichever best describes her, to include her place of work and her residence. Additionally, I'm going to prohibit your physical or constructive possession of ammunition at any time for any reason. And I want to make sure that you understand, when I say constructive possession, I mean there's to be no firearms or ammunition in any vehicle you're being transported in or riding in unless it's...
What grounds? Are you prohibiting me from firearms?
I am.
Why? What grounds?
I am. Because I have that latitude given the severity. Mr. Underwood, Mr. Underwood, in this court, one person talks at a time.
From the solicitor's office and the sheriff's office.
You're going to find yourself in contempt of court.
I've already been in contempt.
Okay.
I'm not here, sir.
All right. Are you going to allow me to finish? Constructive possession of firearms or ammunition means you will not have it in your possession. It won't be in the house or the room that you're staying in. It won't be in the vehicle that you're being transported in, unless we're talking about transport by law enforcement. Do you understand that? All right. That's all. You're dismissed. Officer, if you'll remove him.
Despite the judge's calm demeanor, the deputy refused to show any respect toward him. Some crimes are horrifying, and then there are those that are truly blood-curdling. 25-year-old Ryan Lawrence was arrested and charged after brutally beating his daughter and disposing of her body in a stream. His motive? He was jealous of the attention she received after surviving a rare form of eye cancer.
The sentence and judgment of this court is to receive the maximum sentence of life imprisonment with a minimum of 25 years.
Take a seat at Onondaga County Court, where Ryan Lawrence is about to be sentenced. Before her first birthday, baby Maddox Lawrence was diagnosed with retinoblastoma, a rare form of eye cancer. Despite the intense, time-consuming, and costly treatment Maddox fought through, and this should have been a joyful time for her family. However, her father, Ryan Lawrence, became jealous of the attention she received as a result of her battle with the illness.
What was it that makes people think that he would hurt himself?
Just a message. He left a message with her last night. I don't want to go into the details of it totally, but it just caused some concern for all of us involved that maybe he just wasn't thinking right last night.
Maddox and her father, Ryan Lawrence, were reported missing on February 20th, 2016. 36 hours later, Maddox's body was discovered in a harbor in Syracuse, and Ryan was arrested. In court, it was revealed that Ryan had kidnapped his daughter and taken her to a remote area. Afterward, he placed her charred remains in a container and dumped them in Onondaga Creek. Ryan was initially charged with second-degree murder, but this was later upgraded to first-degree murder.
Hell exists. It's real. I know that. And I created it for myself. You don't have to.
Though Ryan eventually apologized for his actions, his words could not bring back Maddox, and this was clear in her mother's deeply emotional victim impact statement.
Had the audacity of his to make such an uneducated decision on behalf of everyone in Maddox's life.
His remorse did nothing to influence the court's decision either.
Is the sentence and judgment of this court that you receive the maximum sentence of life imprisonment with a minimum of 25 years.
Ryan Lawrence was sentenced to 25 years to life in prison with the possibility of parole. Milia Sotelo, a teenager from Green Bay, Wisconsin, was charged with substance-related crimes and reckless homicide. She was alleged to be the main fentanyl dealer in Brown County schools. On May 17, 2024, the 17-year-old Sotelo pleaded no contest to 3 charges: causing loss of life by delivering substances, aiding in the production or sale of fentanyl, and possessing fentanyl with the intention to sell. She was convicted on all 3 charges. Judge Beau Liégeois sentenced Sotelo to 10 years in prison, followed by another 10 years of supervision.
I am going to sentence you to what the state's recommending: 10 years of initial confinement plus 10 years of extended supervision.
Sotelo's reckless homicide charge was linked to the loss of an 18-year-old in De Pere, Wisconsin in December 2022. At the time, Soetelo was 15 and was charged as an adult. She had given the substances that led to the teen's fatal fentanyl overdose. Soetelo was charged with delivering fentanyl and was found with more than 50 grams of the substance. Authorities found 775 fentanyl pills in her possession, with 60% containing fatal doses. She admitted to selling the substances to pay off a debt to her supplier. During the sentencing, the victim's mother forgave Soetelo, but still held her accountable for her actions.
I believe that you and Malia are responsible for Jack's. However, I also believe that you are deserving of forgiveness. And I do forgive you, Malia. I forgive you because I know that Jack would forgive you.
She thinks Malia can honor Jack's memory, so Soetelo apologized and vowed to change. On January 28, 2015, William Melendez, a 48-year-old former police officer from Inkster, severely beat and choked motorist Floyd Dent during a traffic stop. After pulling Dent from his car, Melendez and other officers kicked, tased, and slammed Dent against a police car's windshield. Dent, who was driving without a valid license, said he didn't stop initially because he didn't realize he was being pulled over. He was later hospitalized for his injuries and faced charges for assaulting a police officer, resisting arrest, and possession of a controlled substance. However, all charges against Dent were eventually dropped, and he reached a settlement with the city of Inkster for $1.4 million. Melendez, on the other hand, faced charges of strangulation, assault with intent to cause great bodily harm, and misconduct in office.
Your dirty, hairy tactics and used excessive force to arrest him. You betrayed your city. You caused your lovely wife heartache. And you caused Mr. Dent severe anguish.
He was sentenced to 13 months to 10 years for the assault and 90 days for misconduct.
Commit you to the Michigan Department of Corrections as to count 1 for no less than 13 months, no more than 10 years. As to count 2, I'm going to give you 90 days.
After serving 14 months in prison, he was released in January 2017. During his sentencing, Melendez expressed remorse for his actions.
Mr. Dent and his family, I am truly sorry if this has caused undue hardships in your personal.
Melendez had previously been involved in several lawsuits for civil rights violations. In one case, Deshaun Auckland sued the city and 7 officers, including Melendez, alleging he was choked and beaten unconscious during a raid in July 2011. Another lawsuit claimed that Melendez and other officers raided a victim's home without a warrant in November 2003 and fatally injured him. In 2003, Melendez and 16 other Detroit police officers were indicted for allegedly planting evidence, falsifying reports, and stealing from suspects. A jury acquitted them in that case, just as they did for Melendez. On September 2, 2019, Mason Cisk took the lives of 5 members of his family in their Elkmont home, firing at each of them in the head. The victims included his father, John Wayne Cisk, his stepmother, Mary, 2 brothers, and a sister. At the time, Mason was 14 and initially told police he was in the basement playing video games when he heard the sound of firing and saw a car drive away. However, this turned out to be false. Mason had taken the lives of his family in cold blood, reportedly out of frustration, claiming, "They argue a lot and I got fed up with it," and that the younger members were also suffering. Further investigation showed that Cisk had serious anger issues and had previously threatened his family. Now, at 18 years old, Mason Cisk is facing sentencing in Limestone County Circuit Court for these terrible crimes.
When your children get up in the middle of the night and they're scared because they think there's a monster in their closet, or they get up in the middle of the night and they're scared because they think there's a monster under their bed, well, Mason Cisk was that monster. And he was that monster in that basement who killed those children.
Mason Cisk was charged with several counts of capital murder for the brutal act against his family. At 18, he was sentenced to life in prison without the chance of parole. On April 6, 2018, he broke into his 98-year-old neighbor Margaret Douglas's home in Wadsworth, Ohio. He filmed her while she was sleeping on the couch and then strangled her. Afterward, he assaulted her body for 2 hours, taking photos and videos. He hid her body in a closet, covering it with clothes and a vacuum cleaner. Police found the videos and photos on his phone during another investigation and arrested him. Ramsey was charged with kidnapping, aggravated burglary, aggravated murder, and abuse of a corpse. He pleaded no contest and was found guilty of all charges.
I'm so sorry for what I did. I constantly live in revenge.
He was sentenced to life in prison without the possibility of parole. Ramsey had previously shown necrophiliac tendencies, trying to get a job at a funeral home a year before the incident. He also had a history of robbing men he met. In the months leading up to the crime, he had been writing about his violent fantasies.
I believe that he planned to kill numerous people and used my aunt as a warm-up, so to speak, for those other crimes.
To simply say I'm sorry to a victim's family, that's not enough. You can't undo their heartache. You can't undo our heart.
Ramsey's mother mentioned that he had long-term mental health issues and had been receiving counseling and medication for years. She attributed a negative change in his behavior to a doctor's decision to prescribe him Zoloft. On April 1st, 2014, 16-year-old Simeon Adams took the life of 24-year-old Nathan Trapuzzano during a failed robbery in Indianapolis. Trapuzzano, a computer programmer and soon-to-be father, was out on his regular morning walk when Adams confronted him and fired at him. Security footage captured Adams leading Trapuzzano into a parking lot where the crime took place. Charged as an adult, Adams faced murder and attempted murder charges for the incident involving Trapuzzano and another man, Eric Douglas. He pleaded guilty and received a 55-year prison sentence for Trapuzzano's loss, along with an additional 12 years for injuring Douglas. Notably, the teenager was seen on camera laughing while heading to the sentencing hearing. The victim's wife stated that she forgives him.
I look at him, he's a human being. He doesn't have the heart and soul that my husband did, and he may never will. But he was still created by God, like every single one of us.
Simeon Adams had a troubled background, characterized by increasing violence. By the age of 10, he had already been detained for mischief. At 12, he and 2 other boys were accused of beating up a kid who had insulted his sister. In 2013, Adams was suspended from school for fighting and later expelled from Indianapolis Metropolitan High School for threatening a teacher and making inappropriate comments. Before the incident, he already had a criminal record. In 2013, he was arrested for burglary and theft after being caught with blue latex gloves and a stolen TV. He was held for several weeks before being released to his uncle, and the charges were dropped when the victim didn't show up in court. In December 2013, Adams was arrested again for stealing a car from a gas station, crashing it, and fleeing from the police. A loaded revolver was found near where he jumped a fence. He faced 6 charges: auto theft, carrying a weapon without a license, possession of cannabis, driving without a license, fleeing from the police, and resisting arrest. Adams accepted a plea deal, admitting to auto theft and resisting arrest. He was also a suspect in other crimes, including the burglary of a weapon shop and an attempted car burglary in a strip club parking lot. Elizabeth Escalona, a 23-year-old mother of 3, had a life marked by a troubled past, including a history of substance use and abusive behavior. She admitted to using substances since she was 13, and her substance abuse continued into adulthood. Escalona continued to use substances and drink, even while out on bond for a previous felony charge. The events leading up to the crime stemmed from her frustration with her daughter Jocelyn Cedillo's potty training. One day in September 2011, Escalona's patience snapped. Overcome with anger and frustration, she brutally attacked her daughter. This horrific incident left Jocelyn severely injured and in a coma. The court proceedings against Elizabeth Escalona began with a flood of emotional and graphic testimony.
Hit her.
You hit her? And what else did you do?
I kicked her.
You kicked her? What else did you do?
I glued her hands.
You glued her hands? What else did you do?
I don't recall what else I did.
Prosecutor Aaron Price did not hold back, labeling Escalona's actions as monstrous and savage. The evidence presented in court was both shocking and heartbreaking. Prosecutors displayed disturbing images of Jocelyn's injuries. The graphic nature of these images left many in the courtroom visibly shaken. During cross-examination, the prosecution projected the words liar and monster on a screen above Escalona's head, highlighting her deceitful and violent nature. One of the most chilling aspects of the trial was Escalona's lack of memory regarding the attack. She claimed she did not clearly remember the beating and had no idea why she glued her daughter's hands to the wall. Neighbors testified to hearing noises coming from Escalona's apartment and described Jocelyn as a sweet girl. The sentencing phase of Elizabeth Escalona's trial brought together the emotional and graphic testimony presented over 5 days. Judge Larry Mitchell was direct as he announced the sentence, giving Escalona 99 years in prison. He described her actions as savage and stated that she had beaten her daughter to the brink of losing her life. His words served as a stark reminder of the seriousness of the crime. As Judge Mitchell declared the sentence, Escalona's family cried out in the courtroom. The aftermath of the sentencing was significant. While Escalona will be eligible for parole in 30 years, the effects of her actions will last a lifetime. John Camfield, a former police officer from Mississippi, was found guilty of causing the loss of Jim Robertson and injuring 4 others in a drunk driving accident in P County, Florida, in April 2017. At the time, Camfield was in his late 40s and was driving with a blood alcohol level twice the legal limit when he hit 5 students from Dundee Ridge Middle Academy as they walked home from a bus stop. After the incident, he fled the scene. Camfield pleaded no contest to DUI manslaughter and vehicular homicide, but claimed he wasn't drunk, attributing the crash to an unspecified illness. He told the judge he couldn't control what happened on April 27th and insisted he hadn't consumed any alcohol that day.
This was not intentional. This is not a drinking and driving issue. This was a medical issue.
However, members of the Robertson family who were present at the sentencing were frustrated with Camfield's refusal to take responsibility for his actions.
You took that away from me. You took that away from my family. You took that away from his sister.
Camfield received a 35-year prison sentence for ending the life of Jim Robertson and injuring 4 others. He was also sentenced to 4 years of probation and had his driver's license permanently revoked. On December 3, 2019, former Kansas City police detective Eric Delir fatally injured 26-year-old Cameron Lamb, who was African American, in Lamb's backyard. Delir and his partner, Troy Schwalm, were responding to a traffic incident involving a red pickup truck chasing another vehicle in Kansas City. They were not in uniform, but wore police vests and entered Lamb's backyard without a warrant, holding their weapons. At the time, Lamb was slowly backing his pickup truck into his basement garage. Delir claimed he saw Lamb reach for a weapon with his left hand and aim it at Schwalm, which led Delir to fire at Lamb 4 times, hitting him twice. However, Schwalm stated that Lamb had his left hand on the steering wheel with his fingers spread and that Lamb raised his left hand, which did not have a weapon. Investigators found a weapon under Lamb's left hand, but he was right-handed, and medical records indicated limited use of his left hand due to a previous injury.
Not asking, we're demanding. We come in from all over the country. We're not going to stand still and let this continue to happen to us over and over again.
Delir was charged in June 2020 by a Jackson County grand jury with involuntary manslaughter and armed criminal action.
First and foremost is this undeniable and uncontested fact. Cameron Lamb is dead, and Eric DeValcon killed him. That's undisputed.
He was convicted in November 2021 and received a 6-year prison sentence.
Eric DeValcon on count 1, the Class E felony of involuntary manslaughter in the 2nd degree, I sentence you to a term of incarceration in the Missouri Division of Adult Institutions of 3 years. On the unclassified felony of armed criminal action, I sentence you to a term of incarceration of 6 years.
He remained out on bond during his appeal, but in October 2023, the Missouri Court of Appeals upheld his conviction and ordered him to be imprisoned. His request for the Missouri Supreme Court to review the case was denied. Darl Cornelius, the final suspect in the 2022 case involving Damaya Eisel, was sentenced to life in prison with the possibility of parole after 25 years by a Lucas County judge. Cornelius was found guilty of aggravated murder, attempted murder, and other charges stemming from the tragic drive-by incident that claimed Damaya's life. The prosecution established that Cornelius and his associate, Byron Cleveland, were attempting to ending the life of Damaya's uncle, Kenneth White, when they fired 11 rounds into his vehicle, tragically ending the life of Damaya, who was riding with him. During the sentencing, the prosecution emphasized the need for a full life sentence to deliver a sense of justice for Damaya's family, friends, and community.
And perhaps in doing so, reinstitute some feeling of justice to her family and her friends and her schoolmates, but also send a message to other individuals in our community similarly situated that this type of violence cannot be tolerated.
Although Cornelius's defense did not contest the damage caused, they requested parole eligibility, hoping it would motivate Cornelius to improve himself while serving his sentence.
Give my client some hope, some positive motivation that when he does go down to the institution, that he can do anything and everything that he possibly can to better himself.
Judge Stacy Cook granted parole eligibility after 25 years, but expressed the urgent need for such violence to end. Damaya's family, while relieved to see justice served, remains heartbroken, feeling that no sentence could ever heal the profound loss.
It's got to stop. The fear of they can't play in their yards, they can't play in their schools. You can't want this for you.
Sean Mahone, speaking on behalf of the family, shared that the trial took an emotional toll on them, emphasizing that no one truly wins in such a tragic situation.
They wanted justice and they received justice, and they was very happy to know that he was found guilty, but it just took so much out of them because no one wins. At the end of the day, you have a young man that's going to prison for the rest of his life, and then you have a family that is still mourning the loss of the grandchild.
Cornelius received a harsher sentence than his accomplice, Byron Cleveland, despite the prosecution's belief that Cornelius did not fire the weapon, but rather drove the vehicle, which still made him a willing participant in the crime. On November 5th, 2008, Kara Jo Roberts, a married woman with 2 children, was found fatally injured in her home. She had been assaulted, and her body was left in the bathtub with the water running. Despite a quick investigation, the case went cold, and police feared a serial killer might be on the loose. Their concerns were proven right when, 2 years later in October 2010, Paige Huser found her 75-year-old mother, Na Whitley, unresponsive at the bottom of the stairs. Initially, Paige thought her mother had fallen due to a heart attack, but police discovered several wounds and signs of assault. As police searched the neighborhood, A witness described seeing a man in his 50s, walking with a limp, driving a black Jeep near Na's house. A sketch was made based on this description. DNA from Na's body was analyzed and matched DNA from the case involving Kara Jo Roberts in 2008. At first, Page didn't recognize the man in the sketch, but later realized it resembled her ex-boyfriend, Jeffrey Morland, whom she had dated for 3 years in college. Jeffrey had worked as a police officer and retired in 2005. He also owned a black Jeep, like the one seen near Na's house. This led detectives to investigate him further. Jeffrey was hesitant to provide a DNA sample, but detectives eventually obtained one when he faced allegations of assault. The DNA matched the samples from both crime scenes, confirming his involvement in both crimes. Jeffrey Morland was arrested, charged with 2 counts of murder and assault, and was found guilty. He was sentenced to life in prison without parole. This is Donald Smith, who is responsible for one of the most heartbreaking and terrifying crimes in Jacksonville, Florida. It all began on an ordinary day in June 2013, when Smith, a 56-year-old man with a long criminal history, encountered Rain Perwinkle and her 3 young daughters at a Dollar General store. Smith appeared friendly and offered them a $150 Walmart gift card, saying they could use it for groceries. Rain, wanting to save money for her family, accepted his offer without knowing the danger she was bringing into their lives. Smith drove Rain and her daughters to a nearby Walmart in his van, which had dark windows and no middle seat, a detail that would later become important. He closely watched them as they shopped, staying close enough to seem helpful, but there was something unsettling about him. After shopping, Smith suggested they get a meal at McDonald's. Rain agreed, and her daughter, Cherish, decided to go with him. What happened next was caught on CCTV. Cherish was seen leaving the Walmart with Smith as they headed toward his van, but they never came back. When Rain realized her daughter was missing, panic set in, and she quickly reported Cherish's disappearance to the police. However, the initial response was frustratingly slow, leaving Rain desperate and terrified for her daughter's safety. The next morning brought the devastating news that no parent should ever have to hear. Cherish's body was found hidden in a marsh. She had been brutally assaulted and strangled. The community was left in shock.
I touched his pants. I had water droplets on my hand, and I said, oh my God, she's in the water. People that have that kind of evil up inside of them, don't need to be here.
Driver, step out of the vehicle. Face away from us. Keep your hands in the air. Stop.
What's your name?
Donald Smith.
Donald Smith?
Yes.
And every day I'm reminded by what he's done. It's not fair that I just don't know what to say. I want to strengthen laws keeping predators locked up where they should be so they don't have the chance to keep getting out, to lure parents such as myself that were naive that day, that I wasn't thinking straight. I had 3 I was by myself. I had no clue he was a predator. He was let out for 21 days before he did this. The police knew who he was. We as a community did not know who he was.
Donald Smith's trial began in February 2018, 5 years after the tragic events. The evidence against him was overwhelming, and the trial progressed quickly. Cherish's mother, Rain, provided a deeply emotional testimony, recounting the worst moments of her life in front of the courtroom. The jury found Smith guilty of first-degree murder and battery.
We, the jury, unanimously find that the defendant, Donald James Smith, should be sentenced to death.
In May 2018, he was sentenced to death.
This court agrees with the jury's recommendation. This court finds that death is the only appropriate penalty for the defendant, given the highly egregious nature of this crime.
What made this case even more disturbing was Smith's reaction, or lack thereof, during the trial. As the gruesome details of Cherish's final hours were revealed and her mother's heartbreaking testimony brought tears to many in the courtroom, Smith remained completely emotionless. He sat there with no expression, showing no sign of remorse or fear, as if he didn't care at all about the pain he had caused or the life he had taken. a former foster parent and Springfield Township firefighter, was sentenced to prison, according to Maumee police. Jeremy Chester received a sentence of 14 years and 4 months to 17 years and 10 months in Lucas County Common Pleas Court. Chester changed his previous plea of not guilty in July and pleaded guilty to charges of gross imposition, endangering minors, and unlawful conduct with a minor. He is set to be sentenced in federal court in November for charges related to child abuse material. This is Gerald Hyde, whose arraignment has just concluded, and he has been sentenced to jail by the judge in Benton County Court, Washington. He was found guilty of possessing a controlled substance. However, he re-entered the courtroom by sneakily slipping past a security guard and took off his prison shirt, hiding his handcuffs in the process. He ran as fast as he could down the corridor before anyone realized he was missing. After glancing around, he removed his signature orange jail sneakers and walked barefoot through the courtroom. As soon as he reached the lobby, he dashed out the front doors and onto the street. However, the police tracked him down at a friend's residence within the next 2 hours, and without further ado, they returned him to custody. On July 29, 2017, police officers Kenneth Elmore and John McCaffrey responded to a family dispute at the home of 20-year-old Kedrick Key in Texas. They encountered a relative leaving the house who had warrants for 3 misdemeanor charges. Body cam footage captured Key walking away as Officer McCaffrey made a comment about a drive-by tasing. The officers pursued Key in their vehicles, eventually catching up to him and using a taser. He was arrested and charged with evading arrest. However, the charges against Key were later dropped when body cam footage contradicted the officer's account.
Drive-by. Drive-by tasing? You know how to chase? Can we do that? Yeah, I'm not going to chase him on foot. I don't need to chase him. My car will chase him, though. Go pick him up. He's me off now.
The footage revealed that Key was never instructed to stop or informed that he was being arrested. It also showed that the officers had lied about having told Key multiple times to obey their commands. In June 2018, Elmore and McCaffrey were charged with altering official records and abusing their authority. A jury found them guilty of felony record tampering in August 2019 and sentenced each to 1 year in jail. They were also required to surrender their licenses as police officers. This story begins with the case of Vonda Smith. Vonda Starr Smith from Afton, Tennessee, was convicted of first-degree murder for the 2016 loss of 21-year-old pregnant Jessie Morrison. During a trial that started on May 25, 2018, State prosecutors Cecil Mills Jr. and David Baker argued that Vonda Smith developed an unhealthy obsession with gaining custody of her grandchild and exhibited extreme emotional distress when she was prevented from visiting during weekends. A minor altercation occurred between Smith and Morrison on August 12, 2016, over the custody of Morrison's son, which escalated into a violent assault and ultimately resulted in the loss of Jessie Morrison's life. On the evening of August 12, 2016, a man walking his dog discovered Morrison's body on an embankment off a secluded section of Judd Neal Loop in Afton at around 7:30 p.m. An autopsy revealed that Morrison had suffered numerous skull fractures, along with various lacerations, bruises, and cuts. The final sentencing hearing for Vonda Smith took place on Monday, June 25, 2018, in the Greene County Criminal Court presided over by Judge John F. Duggar, Jr. Some witnesses testified in support of Vonda Smith. In her victim impact statement, Jessie Morrison's mother, Tammy Morrison, said this.
But can bring my daughter back, or my grandchild. My biggest consolation is she will never see her grandchild again.
As Tammy delivered her statement, tears streamed down her face, and she used a tissue to dry her eyes, visibly expressing her sorrow over her crime. Judge John Duggar had this to say.
As opposed to being with a stranger. And bad things happened. This murder happened after that.
Before sentencing Vonda Smith to life in prison for the first-degree murder of Jessie Morrison and a 25-year prison term for the second-degree murder of her unborn child, she hugged her attorney as she was led out of the courtroom, leaving us to question whether she was genuinely remorseful. The case involving Michael Jackson Bolanos centers around the tragic incident involving Samantha Wohl, who was found lifeless inside her home in the fall of 2023. Initially, Jackson Bolanos was charged with her murder and home invasion, but these charges were later dismissed by the court. However, he was sentenced to a prison term of 18 months to 15 years for repeatedly lying to the police during the investigation.
This is a difficult case. We started with some very, very serious charges, and while it seems like this is not a serious charge, when you add the habitual fourth offense to it, raises it to a maximum penalty of 15 years. And what I have to look at is not just the circumstances of the offense, but also the offender. And habitual fourth raises this up into a straddle cell, 0 to 22 months guidelines, and the 22 months would indicate prison. And although it is a straddle cell, I could choose to give him jail time or just straight up probation. But I also have to look at...
The judge in the case, Margaret Van Houten, criticized Jackson Bolanos for his dishonesty, stating that he lied multiple times, even while under oath on the witness stand. She expressed frustration with his lack of truthfulness, even making a pointed remark that if lying were an Olympic event, Jackson Bolanos would win a gold medal.
Number of times that the defendant lied, and I have to say, if lying was an Olympic sport, you would get the gold medal, sir, because you told lie after lie after lie throughout those interviews, interrogations, and even a few on the stand. And the number of lies does factor into this. Also, the fact that there were prior failures to comply with community supervision, both with an unarmed robbery when he was a juvenile and also for the fleeing looting. And not only was he removed from the Haida prison sentence at the Thumb almost immediately, but was given a sentence of 18 months to 5 years and served out the entire term and never actually achieved parole because there had to have been numerous misconducts that apparently Mr. DeGrazia had looked up, but were not included in this report. But it's obvious there were numerous misconducts for him to serve out his entire time and not get parole.
Despite the dismissal of the more serious charges, Jackson Bolanos was still held accountable for obstructing the investigation through his false statements, leading to his sentencing.
And then the other factor I'm looking at is nothing to do with acquitted conduct or the charges that had to be dismissed pursuant to that case, but also to admitted other crimes that he admitted to on the stand that will never get charged. The breaking and entering into those cars, and taking pictures of cars to send to people to help them steal cars, that's all additional criminal activity. And apparently Mr. Jackson Bolanos, at the time of this offense, had not learned his lesson from all of his prior dealings with the judicial system and the prison system, and was still engaging in theft crimes on the night that this happened. And that's what put him in this place to begin with, and ended up having him charged with the more serious crimes. So it is the sentence of this court that Mr. Jackson Bolanos be sentenced to a period of incarceration of 18 months to 15 years in the Michigan Department of Corrections, with 243 days credit for time served. He must pay $68 state costs, crime victim assessment fee of $130, court costs of $1,300, which is the amount this court has estimated is the average cost of a case coming through this courthouse. It's my duty, sir, to advise you of the right to seek appellate review of your conviction and sentence. If you're unable to afford an attorney, one will be appointed for you. They'll be given transcripts needed to prepare your motions or an appeal. If you wish to seek an appeal, you have to sign and date your appellate rights paperwork and mail it to the clerk of this court within 42 days of today's date. Your client's already initialed the form?
Yes, and Judge, just for the record, you made a reference to my client lying on the stand. Like, that's unsubstantiated that he lied on the stand. That wasn't even alleged that Mr. Jackson Bolanos lied on the stand, but this court made reference to he lying on the stand. And just for the record, Judge, he successfully completed his last probation he was on and 2018. So he demonstrated to the court that he does have what it takes to be successful on community supervision. If you're going back from 2013 when he's 19 years old, I mean, this is 11 years ago at his last probation that he didn't successfully complete it. 2018 was his most recent probation, and he successfully completed that probation, and they closed him out.
Sir, I've heard you out. He may have completed that one, but then he was out committing theft crimes the night of this event.
Okay, but Judge,
admittedly.
Okay, but Judge.
And he's never going to face charges on that.
Okay, so that's uncharged conduct, and Judge, if they wanted to charge him on that, they could have charged him on that. But in this building, Judge, we got to be honest with ourselves. How many individuals get sentenced to prison for lying to the police, especially if they're not being charged with any type of larceny? That just doesn't happen.
How many of those people are habitual fourth offenders? I'm done. That is my sentence. You can take it to the Court of Appeals.
His defense attorney, Brian Brown, expressed displeasure with the ruling and vowed to appeal the sentencing, while the prosecution indicated they would appeal the dismissal of the murder and home invasion charges. In Henderson, Las Vegas, an incident on the highway escalated into attempted murder between two rival motorcycle gangs. On Memorial Day, May 29, 2022, members of the Vagos Outlaw Motorcycle Gang were fired at while riding back from an event in Boulder City. The individuals involved were members of the Hells Angels Motorcycle Club. Police arrested 3 suspects. Richard DeVries, the 66-year-old president of the Hells Angels Las Vegas chapter, along with 46-year-old Stephen Alo and 26-year-old Russell Smith. Reports say that during the event, 5 Hells Angels members were seen following the Vagos group, causing trouble. They left the event before the Vagos members started riding toward Henderson, where the Hells Angels set up an ambush. 6 Vagos bikers were injured, and the highway was closed for several hours for the police investigation. The injured riders were taken to a local hospital. Police, working with the Las Vegas Metropolitan Police Department's Criminal Intelligence Unit, identified the 3 suspects through surveillance and civilian footage of the incident. In June, DeVries and the others were arrested and charged with 6 counts of attempted murder with a deadly weapon, conspiracy to commit murder, 6 counts of battery causing substantial harm with a deadly weapon, and 6 counts of firing a weapon into an occupied vehicle. These charges included gang-related enhancements. Additionally, 5 more Hells Angels members were indicted for attempted murder, racketeering, and harboring concealed weapons. Former Las Vegas Special Agent Aaron Rouse suggested that the recent arrests could lead to federal RICO charges against the Hells Angels, based on their activities, which might even result in the dissolution of the Las Vegas chapter. Richard DeVries, the Hells Angels. Las Vegas chapter president was able to post bail after his indictment by the Clark County grand jury. He appeared in court on August 24, 2022, with his attorney, Richard Schanfeld. However, DeVries was rearrested on October 3, 2022, facing additional felony charges, including racketeering. Despite his calm demeanor in court, he was ordered by Judge Tierra Jones to be held on a $250,000 bond, which he again posted. During a separate court hearing on March 31, 2023, involving all the other suspects, DeVries' attorney argued that the evidence used to indict the Hells Angels members was weak. He also claimed that Vago members had concealed weapons during the incident, some of which had been examined and returned by police. As a result, the judge instructed prosecutors to revise the indictment. On May 1, 2023, Judge Tierra Jones ruled that the 7 Hells Angels members, including DeVries, would not face racketeering or gang charges for the highway incident, which injured 7 people. The judge also reduced the number of counts related to the incident from 25 to 5. DeVries' attorney welcomed the decision, saying the initial indictment was too broad. DeVries, along with 6 other men, now including Cameron Tretch, Aaron Chun, and Ryan Malazgo, still faces charges of attempted murder, battery, and assault with weapons. Although they have all pleaded not guilty, they could face up to 40 years in prison if convicted. Their trial is set for May 28, 2024, nearly 2 years after the incident. For now, DeVries and the others are free, but they could face serious consequences after the trial. In Essex County Superior Court, 35-year-old Bloomfield police officer Sean Corder faced several charges, including conspiracy to commit official misconduct, tampering with public records, falsifying public records, and false swearing. On June 7, 2012, Officer Corder responded to a call at Marcus Jeter's home after a verbal argument. Jeter left voluntarily, but was followed by Corder onto the Garden State Parkway, where he was stopped. Corder tried to remove Jeter from his vehicle, but Jeter, fearing for his life, refused. Corder called for backup, and when they arrived, they rammed Jeter's car. Corder then broke the window and, with help from the backup officers, forcibly removed Jeter from the vehicle. The officers then filed police reports falsely claiming Jeter tried to grab Corder's weapon and had attacked one of the backup officers. Jeter was charged with eluding, resisting arrest, aggravated assault, and attempting to disarm an officer. Later, new evidence led to all charges against Jeter being dropped and an investigation into the officer's actions, resulting in a grand jury indictment. Before his sentencing, Officer Sean Corder addressed the judge in Essex County Courthouse.
I love my children more than anything in the world, and I know they need me. I don't want them to have to suffer, switch schools, lose friends, lose the house that they're raised in.
Marcus Jeter, the victim in the case, was present in the courthouse and also shared his thoughts about Sean Corder and the entire ordeal.
To say that I resisted. He had a choice. I'm not saying that that messes his character up. I'm not saying that he's not a good guy. I'm just saying that in a situation like this where he has an obligation, a moral obligation to tell the truth, he chose not to.
After being convicted of official misconduct and tampering with records, former Bloomfield police officer was sentenced by Essex County Superior Court Judge Michael Raven to 5 years in state prison. Numan Raja, a former Palm Beach Gardens police officer, was found guilty of manslaughter and attempted first-degree murder for fatally injuring Corey Jones in 2015. On October 18, 2015, around 3:15 a.m., Officer Raja, who was on duty but not in uniform, approached Corey Jones's stalled car on an I-95 off-ramp in Palm Beach Gardens. Jones, a church drummer and reggae band member, had a concealed carry permit and was talking to a roadside assistance operator when Raja approached and asked if he was okay. Jones replied that he was fine, but Raja reacted aggressively, demanding confirmation. He then yelled and swore at Jones, ordering him to raise his hands. Feeling threatened, Jones drew his weapon and attempted to flee. Raja fired at him, hitting Jones 3 times. Even after Jones dropped his weapon, Raja continued firing, hitting him 3 more times and fatally injuring him. Raja claimed he identified himself as a police officer and fired at Jones in self-defense. Prosecutors disagreed, stating that Raja never identified himself and that Jones likely thought he was being carjacked or attacked. A phone recording of the incident captured Jones, but Raja was not heard identifying himself as a police officer. Jones's weapon was found 125 feet away, unfired. Raja was sentenced to 25 years in prison, serving the sentences for both crimes concurrently.
Count 1, I hereby sentence him to 25 years in the Department of Corrections. And on count 2, I hereby sentence Mr. Raja to 25 years in the Department of Corrections.
First of all, I'm sorry for Corey Jones' family, their loss. It was a difficult situation. Sometimes good people make bad decisions.
Raja's conviction marked a significant moment for many African Americans who have lost loved ones in encounters with law enforcement. It was the first time in 30 years that a Florida police officer was found guilty and sentenced for ending the life of an African American man. Despite Raja's attorneys appealing to the Florida Supreme Court, arguing that the manslaughter and attempted murder convictions constituted double jeopardy, the appeal was rejected. As a result, Raja remains in prison and is expected to be released on February 27, 2044. Sean Corbally, a Central Indiana man with 2 previous convictions for serious offenses, was found guilty of assaulting a Greenwood mother at knife point. Corbally had been released from jail in February 2010 after serving less than 12 years of a 25-year sentence for a serious offense. In September 2000, officials from the Indiana Department of Corrections reported that Corballi's sentence was reduced due to his good behavior, educational credits, and participation in substance addiction rehabilitation. Upon his release, he was labeled a violent predator and placed on 5 years of probation. While on probation, Corbally broke into the home of a Greenwood mother of 2. in July 2012 through an unlocked patio door. He threatened to harm her daughter and son with a dull knife if she resisted his unwanted advances. Corbally assaulted the woman and fled. Although he had been arrested for a different assault less than a week prior to the Greenwood crime, he was released due to a lack of evidence. However, DNA evidence found at the crime scene led to his rearrest. The 35-year-old victim submitted a letter to the jury in court, expressing her feelings about Corbally. Judge K. Mark Lloyd of Johnson Circuit Court described the case as malicious and stated that the evidence against Corbally was overwhelming. After a 3-day trial that concluded on February 28, 2013, he was found guilty of rape, unlawful confinement, deviant criminal behavior, and burglary resulting in bodily harm. Corbally was sentenced to 270 years in prison. He displayed no signs of remorse after the verdict was delivered, maintaining his innocence. He was seen speaking to the police before eventually smiling as he was led out of the courthouse. Robert Olson, a former Georgia police officer, was convicted for fatally injuring Anthony Hill in 2015. Hill, an unarmed Air Force veteran diagnosed with PTSD and bipolar disorder, was fatally injured by Olson while responding to a call about Hill behaving erratically outside an apartment complex in Atlanta. Olson was convicted of aggravated assault, violating his oath of office twice and making a false statement, but he was acquitted of 2 counts of felony murder. During the trial, Olson claimed he acted in self-defense because he feared for his life. Prosecutors argued that he used deadly force unnecessarily against someone experiencing a mental health crisis. Olson received a 20-year sentence, serving 12 years in prison and the remaining 8 years on probation.
Based on the charges that you were convicted of, I am going to sentence you to 20 years to serve the first 12 in custody. You will get credit for the 2 days that you served. You are not allowed to ever work in law enforcement. You are not allowed to possess any firearm.
During the sentencing, Hill's father spoke about his son.
We will never be able to see Tony again. We'll never be able to speak with Tony again. We'll never be able to hug Tony again. We'll never be able to say I love you to Tony again. We'll never be able to do any of these things. We do not have that opportunity. It was taken away from us.
Although it cannot bring their son back, I hope the sentencing will provide them with some relief and a sense of justice. Mark Anthony Gonzalez was accused of fatally injuring Bexar County Sheriff's Sergeant Kenneth Van in 2011 and faced a murder charge. He attacked Van in May 2011, resulting in immediate fatality. Due to the sensitive nature of the case, both defense and prosecution agreed to conduct the hearing in private. Gonzalez's mental competency was closely examined to determine his ability to stand trial. The trial assessed whether the death penalty, already handed down, was suitable given his mental condition. Recordings of phone calls where Gonzalez discussed the case and the jury were played in court as part of the proceedings.
Good jury. We took 5 weeks to pick this jury, so it's a 50-50 now. It's a 50-50 chance, you know what I mean?
The recording and Steve Starling's testimony in Judge Mary Roman's courtroom, where Gonzalez chuckled and said, "I killed a cop, don't tell anyone, not even your wife," undermined his defense in the competency trial. On sentencing day, Yvonne Van, Sergeant Van's wife, was also given the opportunity to address the court.
I will never have any more alone time with my husband, and my time now is truly alone in every sense of the word.
She spoke about forgiveness and the difficulty of forgiving a man who had abandoned her and her child. Now, here's the official decision from Judge Mary Roman.
You are hereby sentenced in accordance with Texas law to death.
Throughout the court proceedings, Gonzalez remains mostly silent. His calm demeanor would almost be impressive if it weren't so chilling. Now, he is destined for Texas death row. This is Marcus Eberhardt, a former police officer from East Point, Michigan, who became the center of a nationwide debate in 2014, along with fellow officer Howard Weems. Eberhardt tasered 24-year-old Gregory Towns, resulting in his loss of life on April 11, 2014. The 2 officers were responding to a domestic violence call made by Towns' girlfriend, Aisha Smith, who reported that Towns had abused her. When Eberhardt and Weems arrived, Towns tried to run but was caught and handcuffed. Eberhardt told him to walk to the patrol car, but Towns said he was too tired and refused. Eberhardt and Weems then used their tasers on him repeatedly until he became unresponsive. The prosecution argued that this was a violation because Towns was already handcuffed and having trouble breathing when he was tasered. The defense initially claimed that Towns' demise wasn't caused by the taser, but by a rare sickle cell trait. Eberhardt was eventually charged with involuntary manslaughter and felony murder. This wasn't his first time in trouble. He had a history of aggressive behavior. The case highlighted the need for police reform and accountability. It was revealed during the investigation that Eberhardt used the taser on Towns for more than 40 seconds, going far beyond department policy. The defense argued that Eberhardt didn't know about Towns' health issues and was just following his training. However, the excessive taser use led to his charges. This case was significant as it was the first time a police officer in Michigan had been convicted for using a taser on someone. Eberhardt was sentenced in December 2016. He showed no emotion during the sentencing, where he faced up to 15 years in prison and seemed eager to leave the courthouse. His lawyer expressed disappointment in his behavior, but offered little defense or remorse. Eberhardt's lack of response further upset the public. Eberhardt was sentenced to life in prison for his actions. Although no statements were made during the sentencing, Eberhardt later released a statement expressing remorse. He acknowledged the pain he caused to Gregory Towns' girlfriend and child, saying, "I'm truly sorry for the pain that I have caused the Marshall family. I know nothing can bring back their loved one, but I take full responsibility for my actions." While his apology showed regret, it couldn't undo the harm done. The case brought attention to the use of force by police. For Towns' family, Eberhardt's conviction provided some relief, knowing he was held accountable. Aisha Smith, Towns' girlfriend, expressed her struggle, saying she was working on forgiving herself for calling the police, despite the tragic outcome. In Tampa, Florida, Dante Morris is on trial for the fatal attack on 2 police officers during a traffic stop in Tampa Bay. He faces 2 counts of first-degree murder. In June 2010, officers David Curtis and Jeffrey Kokab pulled Morris over, unaware of the tragic outcome that awaited them. Morris attacked and fatally wounded both officers on the spot. As his trial starts, the courtroom is filled with those eager to see the outcome. Among the witnesses is his ex-girlfriend, Ashley Price, who is testifying against him.
Can you please point to where he is and describe an article of clothing?
With a red shirt. That he did it.
That he did it?
Yes.
Did you know what he was talking about?
Oh, yes.
Had he referred you to something, to look at something?
To watch the news.
Ashley testified that Morris had told her details about the incident, including where he attacked the officers and their race.
Did he tell you where he shot them, what part of their bodies?
Yes.
And where did he tell you he shot them?
In the head.
And did he use a descriptive term for them that let you know what race they were?
Yes.
And what term was that?
Crackers.
Here's a statement from a family member. Officer Kokab's sister made sure to tell Morris how she felt about the situation.
I will never, ever be able to make new memories with my brother, now or ever again.
Here's what Officer Curtis's mother felt.
Now ask this court to put him to death immediately without hesitation.
This case attracted significant public attention and scrutiny, partly due to the release of the key piece of evidence, the police dashcam footage. Some believed it raised questions about potential compromises within the police force, while others argued it was done to protect the families of the slain officers.
That's count 1 for the first-degree premeditated murder of David Curtis. The court imposes a sentence of death. As to count 2 for the first-degree premeditated murder of Jeffrey Kokab, the court imposes a sentence of death.
Morris appears dejected as he leaves the courtroom, walking with the demeanor of someone resigned to the certainty of his impending death. David Chalue is part of a trio with Caius Veiovis and Adam Lee Hall, all involved in a murder. Chalue, a 47-year-old from North Adams, faced trial as the second defendant in a 2011 triple homicide case that gained national attention due to the gruesome nature of the murders. The disfigured bodies of 3 men from Pittsfield, David Glasser, Robert Chadwell, and Edward Frampton, were found in Beckett in August 2011. Police and prosecutors stated that the victims were abducted, attacked, and mutilated. Prosecutors claimed Chalue was one of the men who carried out the murders. Chalue denied the charges of murder and related offenses. David Casey, a key witness, described how Chalue and Hall dismembered the 3 men, cutting off their legs, hands, and heads. One of the killers reportedly said he slept well after the murders. Shalu's lawyer argued that the witnesses were jailhouse informants and unreliable. Prosecutors said Hall, the main suspect, wanted Glasser dead to stop him from testifying in another case, and the other 2 victims were killed to eliminate witnesses. Berkshire District Attorney David Capeless recommended 3 consecutive sentences with no chance of parole. Hampton Superior Court Judge C. Jeffrey Kinder agreed, saying each victim's life needed to be recognized. Kinder called the murders extremely cruel and noted that Shalu preyed on the disabled and controlled young women. Kinder said he would not hesitate to give the harshest sentence possible in Massachusetts. Capeless agreed, urging the court to show no mercy, noting that Shalu had shown none to the victims. After long deliberations, the jury gave their verdict.
Premeditation with malice aforethought. Mr. Foreman, was this the verdict of the jury? Yes. Ladies and gentlemen of the jury, was this your verdict? Yes. And was this verdict unanimous? Yes. You, the jury, further find that your guilty verdict of murder in the first degree is also based upon a theory of extreme atrocity or cruelty. Was this the verdict of the jury, Mr. Foreman? Yes. Ladies and gentlemen of the jury, was this your verdict? Yes. And was this verdict unanimous? Yes.
As the verdict was read by the judge, Shalu showed no emotion. He simply didn't care. Shalu received 3 life sentences for his crimes. However, he is not giving up. He wants his sentence overturned and has taken his case to the Supreme Court. Shalu appealed his conviction, citing several errors from the original trial that influenced the outcome. However, the Supreme Court rejected the appeal, stating that the first-degree murder verdicts were just. During the appeal, Shalu's lawyer argued that several mistakes were made during the original trial that affected the outcome.
With regard to the photos of the weapons, this court found error in both the Viovis and Hall decisions with the court's admission of the evidence of the studded baseball bat. That evidence was admitted here, but unlike in the cases of Viovis and Hall, the forensic testimony here was not the same.
Specifically, he argued that the judge gave improper instructions to the jury, allowed the admission of unfairly prejudicial character evidence, and rejected the prosecution's argument regarding statements made by Hall. Additionally, the appeal claimed that the prosecution made multiple inappropriate statements during their opening and closing arguments. The court reviewed the 2013 trial and concluded that there were no grounds to overturn the convictions or reduce the sentences. Zion Foster, a 17-year-old from East Point, Michigan, went missing in January 2022 after being picked up by her cousin, Jalen Brazier. When Zion disappeared, Brazier initially lied to the police about his involvement, which led to a long search for her. Eventually, Brazier admitted that Zion had passed away while with him, though the details of how she lost her life are still unclear. Panicking, he disposed of her body in a dumpster in the Detroit area. Brazier was arrested for lying to investigators during the investigation into Zion's disappearance. Even after admitting he disposed of her body, he didn't immediately say where it was, which delayed the search. In 2022, he was sentenced to prison for his role in Zion's demise and for obstructing justice by lying to the police.
Second, the sentencing guidelines did not properly consider the defendant's lack of potential for rehabilitation. In addition to his pervasive prevarications, he remains largely unable to accept responsibility for his undisputedly established behavior. When the drafter was asked, a drafter of the pre-sentence investigation report was asked whether there was any statement he'd like to have noted in his report, he said, "I didn't murder her, but the jury found me guilty." Well, I'm not surprised that the defendant continues to deny his role in the victim's death. His response reveals that he's incapable of accepting responsibility of the suffering he's caused Zion Foster's family. He's barely acknowledged that he should have called 911. He's not really acknowledged that he should have not have put Zion Foster's body in a dumpster. And he's really not acknowledged that he should not have deceived law enforcement. His internet searches do not reflect concern for Zion Foster. Instead, they reflect that he was only attempting to learn ways to avoid taking responsibility. His case was not the act of an impetuous 16-year-old who was influenced by a group of his peers. He acted alone. Defendant's cold indifference and self-absorbed conduct leading up to Zion Foster's death through today made it clear that he's unlikely that he can be rehabilitated. Third, the relationship between the victim and the aggressor provides a reason to exceed the sentencing guidelines. Zion Foster considered defendant her favorite cousin, yet defendant only viewed her as a potential source of pleasure. He took advantage of her young age and naivete. Then after she became a liability, he disposed of her in a heartless manner. In exchange for her friendship, he made every effort to protect himself by lying to law enforcement and lying to Zion Foster's family. He did not call 911 for his beloved cousin, who he insists he did not murder. Instead, after it was clear that his lies were not leading law enforcement away from him, he called a lawyer and spoke to police, which he later regretted, to minimize his exposure to prison time. The victim in this case was not a rival. She was not someone who threatened him. She was not someone who provoked him. She was not someone who showed him disrespect. He coldly disposed of one of the greatest admirers. His greatest admirers, while his girlfriend was pregnant with their third child, was working the night shift, and his two young children were asleep in his home. Defendant deceived his girlfriend and left his children at home unattended. This case illustrates that defendant has no concern for anyone other than himself, including his closest family members. All of these facts lead this court to believe that the defendant has a poor chance for rehabilitation. As such, to ensure the protection of the community, a sentence that is longer than contemplated by the sentencing guidelines is warranted and necessary. Fourth, consecutive sentences are also appropriate in this case. The tampering involved the body of Zion Foster. The jury verdict reflects that it concluded that defendant disposed of the victim's body to conceal the way that he killed her, as well as to conceal the fact that he had killed her. The effort was followed by a torrent of lies to Ms. Foster's family and law enforcement. Defendant's admission that he disposed of Zion Foster's body to police weeks after her murder was part of an ill-conceived attempt to avoid taking responsibility for Zion Foster's death, especially considering his changing stories about the cause of her death. So for these reasons, the defendant is sentenced to 38 to 90 years with a consecutive sentence of 5 to 10 years on count 2 with credit for 356 days served. You're to pay a crime victim's assessment in the amount of $130. You're to pay court costs in the amount of $1,300. The State Court Administrator's Office has determined that $1,300 is the average cost of this court of a case that proceeds through it, and it covers salaries and benefits for court personnel, goods and services necessary for the operation of the court, and necessary expenses for the operation and maintenance of court buildings and facilities.
Zion's family has been left in deep pain as they still don't have clear answers about her loss or the location of her remains, which have not been found. Ali Abulaban, also known as Jin Kid on social media, was a popular TikTok and Instagram content creator who became well known for his comedy skits and voice impressions. In 2021, his life took a dark turn when he was arrested for ending the life of his estranged wife, Ana Abulaban, and her friend, Ray Barron. On October 21, 2021, Abulaban entered Ana's apartment in San Diego, where she lived after they had separated. He had secretly installed a listening device on their daughter's iPad to eavesdrop on Ana. Hearing that Ana was with Barron, Abulaban went to the apartment and fired at them both while they were sitting on the couch, then fled the scene. Afterward, he picked up his daughter from school before being arrested. Abulaban confessed to the crimes, leaving the jury to decide how serious the offenses were. They found him guilty of 2 counts of first-degree murder, concluding that he had planned the acts and acted with intent.
Ali Nasser Abulaban, guilty of the crime of murder in the first degree of Ana Abulaban, in violation of Penal Code Section 187, Parent A, as charged in Count 1 of the information. And we further find the allegation that in the commission and attempted commission of the above offense, the defendant, Ali Nasser Abulaban, intentionally and personally discharged a firearm, to wit, a handgun, and approximately caused great bodily injury and to a person within the meaning of Penal Code Section 12022.53, parent B, to be true. Special circumstance as to count 1 and 2, and we further find the allegation against the defendant, Ali Nasser Abulaban, that he has in this proceeding been convicted of more than one offense of murder in the first or second degree within the meaning of Penal Code Section 190.2, parent A, parent 3, to be true. Dated May 28th, 2024, jury foreperson. Ladies and gentlemen of the jury, was this and is this your verdict as I have just read to you?
Yes. You decide which to pull the jury.
Yes, please.
Ladies and gentlemen of the jury, I will ask you individually, was this and is this your verdict as I have just read? Please answer yes or no to that question. Juror number 1, was this and is this your verdict?
Yes.
Juror number 2, same question.
Yes.
Juror number 3, same question.
Yes.
Juror number 4, same question.
Yes.
Juror number 5, same question.
Yes.
Juror number 6, same question.
Yes.
Juror number 7, same question.
Yes.
Juror number 8, same question.
Yes.
Juror number 9, same question.
Yes.
Juror number 10, same question.
Yes.
Juror number 11, same question.
Yes.
And juror number 12, same question.
Yes.
Your Honor, all answer in the affirmative.
Charlie, record the verdicts. Ladies and gentlemen, you have now completed your jury service on this case. On behalf of the judges of this court, please accept my thanks for your time and effort. Now the case is over, you may choose whether or not to discuss the case and your deliberations with anyone. I will remind you that under California law, you must wait at least 90 days before negotiating or agreeing to accept any payment or information about the case. Let me tell you about some rules the law puts in place for your convenience and protection. The lawyers in this case, the defendant or the representatives may now talk to you about the case, including your deliberations and verdict. Those discussions must occur at a reasonable time and place and with your consent. Please immediately report to the court any unreasonable contact made without your consent by the lawyers in this case, the representatives, or the defendant. The lawyer, representative, or defendant who violates these rules or violates the court order may be fined. I will now order that the court's record of personal juror identifying information, including names, address, and telephone numbers, be sealed until further order of this court. If in the future the court is asked to decide whether the information will be released, the notice will be sent to any jurors whose information is involved. You oppose the release of this information and ask that a hearing on the issue be closed to the public. The court will decide whether and under what conditions any information will be disclosed. Ladies and gentlemen, it's been a long trial. Thank you very much for your service on this case. I spend a lot of time watching you, and you were very focused, very diligent in assessing the credibility of people, and I appreciate your effort in this. The attorneys appreciate your efforts, so thank you very much, and we will see you in 3 years. So you are now allowed to leave. Thank you very much. What's his custody status? No. All right, so the defendant will remain out on no bail. What kind of sentencing date do you want?
What's the course?
Counsel, due course sentencing is June 27th. That is a Thursday. It would be at 9 o'clock.
Would the court prefer to do it on a Friday, or does it have any preference to when we do it?
Whenever you guys. What date is it?
It's a Thursday, Your Honor. June 27th. At the end of the month.
One, we could do Friday morning.
The 28th?
Yeah.
That's fine.
Sir Boulevard, you have a right to be sentenced within the statutory terms. Do you waive that right, and I will put it over 1 day?
Yes, Your Honor. Yes, Your Honor.
Thank you, Mr.
Probation hearing and sentencing will be on June 28th at 9 o'clock a.m. in Department 2002.
All right, we'll be in recess.
Members of the audience, please wait in the hallway.
Yeah, give me a second. No. It's just, you guys take it all back and then, yeah, that's just the way I operate. So in case anybody says anything, it's like, nope, detective has it. I've always done it for 25 years. Like, I work that way. So,
Charlie, this is yours, right?
No, none of that's mine.
So all of this, okay.
I think it might be you guys.
Thank you. Okay, just throw these away. I want to make sure that that's...
Yeah, you can just toss it all. You can just toss it over there.
All right, I'll just throw it off Peter's.
Throughout the trial, Abulaban showed a lot of emotion, especially when he talked about his rocky relationship with his wife and feelings of betrayal. This case reveals a 15-year-old with a terrifying secret. His actions will leave you shaken, and after his day in court, you'll be left wondering if he's truly just a child. On October 23, 2013, a student at Frontier Middle School entered the building armed with a weapon, a knife, and more. The court sought answers in this disturbing case. When the accused first appeared in court, his unsettling behavior shocked everyone, making it clear that he wasn't an ordinary child like the others.
What's your middle name?
Jacob.
And what's your date of birth? So you're how old?
11.
And your name, ma'am?
Carla.
Mother?
Carla.
Mother? Sir? Father? Thank you.
Does he have any money? Do you have any money?
No.
Okay, Mr. Watson?
You look for over there. I just found this your son. Thank you. Come on, can you say I'm moving forward?
Well, Your Honor, in regards to the anticipated charges, the weapon at school under 941-280 requires an evaluation before he gets released. I think that evaluation should occur in his case. So today we're asking to be held. Pretty serious matter. Weapon was recovered. And I have to applaud parents in regards to getting a handle on this early before something serious happened. And, I think that we need to take a look at Quincy's mental state before we take up issues of release.
And they just said that 941 those conditions that is to take place if your child is over 12, but I think since your parents 12, I will say it's when you apply to your.
Okay, the only thing I would ask, Your Honor, is I don't know if there's inquiry of the parents that are concerned regarding mental health issues for him and whether or not they would feel comfortable having involvement controlling if there's someone to supervise him 24/7. We can still provide the state the assurance that he's being properly monitored, can still get him to whatever evaluations are needed. And again, the statute indicates it's over 12. So I'm not sure what the situation at home as far as supervision is concerned, if there's someone there all day. I understand the state's concern. Obviously, with these charges, there would be that type of a concern, but I'd ask the parents to possibly reassure the court, or at least address the issue with the parents. Is someone at home to monitor him?
I'm home all day.
You're home all day? Okay. And as far as any issues regarding any phones in the home at this time? Okay. any other dangerous weapons that are in the home. So that being said, Your Honor, I'd ask the court to possibly consider releasing the parents. I understand the concerns. We can still move forward on getting an evaluation, maybe expedite that evaluation by having them released. I
think that we are required to have an evaluation take place here almost immediately.
Huh.
So I'm assuming that would take place today if you want this back on tomorrow.
I'm not sure we'll be able to get a report back in time in that reference. Can we tentatively schedule it for tomorrow? And we'll probably possibly reset it. If I find out that the report won't be ready, I don't think there's a need to bring the parents back out here tomorrow morning.
Probably better on Monday.
I had planned on being on Monday, correct, but I just don't know how.
Okay, good.
Is Dr. Cross in today?
Yeah.
Okay. So let's put it on for review tomorrow morning, and we'll see where we're at. And then we'll, if need be, we'll set it back over to Monday. Yeah.
The attorney, focusing on the defendant's mental health, argued for rehabilitation instead of punishment. However, the seriousness of his crime made the idea of his release a dangerous risk for the whole community.
You know, this isn't an anger situation that just cropped up and it's like a one-day thing or something like that. This is something that's been going on the whole month of October. I do applaud the parents for recognizing that this young man has anger issues and getting him into counseling. But the bottom line in regards to it is, what kind of response is this young man having to that counseling? And it hasn't gotten better, it's gotten worse as he's been confronted with these things. Now, I know from these reports that he has a little bit of difficulty with the, supervision of his dad, and, dad, rightly being a father is the person that, has to tell him what to do sometimes. But his response to that is not good. The taking off and the having suicide thoughts and things like that. And it's not just once or twice, but on multiple occasions, it is very troubling. And when we look at the facts of the charges, I'm concerned about the scenario of events that are occurring there too. First, he steals his parents. Now that isn't something where he just sees it laying out and he just grabs it. And he has to think about that, and he thinks about it for a while before he does it. And then he does it and he hides it, and he's successful in regards to hiding it. I believe that occurred on the 17th. He takes that to school on the 18th. That's by his admission and the admission of another young man at school. Apparently there's some issues that occur where he takes off from school that day, I believe with his friend. He brings that gun back on the 21st. So he's successful in regards to hiding that thing for an extended period of time. He brings that gun back on the 23rd, and on the 23rd is the date where we become very concerned. First, there's a school official that tries to have contact with him because he had taken off, and his response there was basically to go ballistic. He doesn't want to go into Miss King's room. He tells her, "I'm not going to ever tell you anything." He says, "You don't know what I'm capable of," and basically escalates to the point where she sends him back to his first period class rather than dealing with the issues of him taking off from school earlier. In regards to the planning, we have statements from another young man where he made statements where he should maybe just do this during the first period class, and decides to wait until later in the day when kids are leaving on the bus because it would have more of an impact and people would see that and be afraid of him. The whole scenario that we're seeing is a young man who's making very determined and calculated, taking a calculated procedure in regards to the things that he wants to accomplish. And when adults are intervening in regards to it, his response is to be hostile, angry,
and then come up with, the idea of hurting someone else or hurting himself. And this hurting himself isn't, again, that's not just a one-time thing. His going to the ER and being treated for suicidal thoughts earlier, that was before any of these things occurred. So I am concerned. I'm concerned that he's not taking this seriously. I do believe his mom is. I believe that she saved him from a life of sorrow. But the bottom line in regards to these are serious charges. He's looking at a couple of years in a juvenile institution. He's looking at very intensive counseling to hopefully get him back on the right track. And, those issues are not going to go away. I see him as a risk to himself. I see him as a risk to others. There's I think a 6-year-old sister in the home as well, as an older sibling in the home. In good conscience, I can't make any kind of a recommendation that he be released at this time.
After considering all arguments, the judge made her decision, and the defendant's response confirmed her belief that justice had been done.
We're not going to address the specific allegations of Mr. Wilson. A lot of those allegations were raised in the probable cause declaration that the court has already reviewed. Regarding his behavior with adults, although there was an outburst, part of that is in relation to the mental health counseling he was getting and whether or not the school was addressing his issues in a proper manner. Both of that, Ms. King and the security guard were present when they wanted to have a conversation with him. And the security guard had physically grabbed him in the prior week or the prior day, which resulted in the outburst. They agreed, the school, that they might be better to just have the school counselor address some of these issues. That was before the issues on the weapons came up. As far as respectful nature to family, there's never been an issue raised regarding any threat to family members. And in regards to his behavior, when law enforcement came to the school and interviewed him, there was one initial outburst with an officer, but then the officers were comfortable enough during the process of the interviewing to release him from handcuffs, and allow him to sit with the school administrator because he was being calm and very, very cooperative. The admissibility of his statements are all issues we still need to address. And the statements made by the other young man, we haven't been able to address either. The boy, I should say. So I understand the state's concerns. Many of these factors have all been addressed with what the family has done since he's been brought into custody and the escalation of mental health services that we're now looking to try to get for him. Yes, there were issues before his arrest. We don't deny that we're going to be addressing those issues before the court. But as far as going forward, the court is looking at what is the least restrictive going forward and what may be the ability to protect the community and protect himself. I think the family has put that into place along with the help of the Children's Center and as well as the help of Catholic Community Services. So that going forward from this date, if the court releases them, there are a number of fail-safes to make sure that this young man doesn't have a reoccurrence of the prior offense. Plus, we're also assured by mother's actions that if something should arise, an outburst, a disagreement, an argument by him, that mother will call detention, will call law enforcement to bring him back into detention.
All right, thank you, Mr. Wiggins. Well, obviously this was a very difficult decision for the court to make. It's a lot of information, and I did take opportunity to review not only Dr. Shen's progress note, the letter from Dr. Ferber, as well as the home visit that was done yesterday by juvenile court. Counsel is correct that RCW 1340-040 directs the court in terms of deciding whether or not to continue holding him in detention, and if there's probable cause to believe that detention is required to protect him either from himself or that he's a threat to the community safety at large. I believe in this particular case that the risk, not only to the youth, but also to the community, outweighs the protective factors that have been identified in the materials that were provided to me. I have concerns about the mental health issues, the ideation, the anger. Also have concerns about the response that was made by the family during the month of October. And that's identified specifically in 3 contacts with either hospital, Children's Center, etc., in the report that Dr. Shen provided. I'm not
I've been told this morning that now there's locks on the front door and back door, but as of yesterday, they were not operational. So I feel that at this point he needs to be held in order to protect him from himself and also to the community. So that's going to be my decision today.
Your Honor, at this time, can we set a review date of 2 weeks in order to address the competency evaluation and see where we are with Dr. Johnson? Try to see if we can fast track that. 12th.
Yes.
That'd be 12th, yeah.
November 12th.
At 9 a.m. Your Honor.
9 a.m.
Thank you.
Thank you.
Thank you.
All right. Now we'll conclude our document.
Don't make things worse. Hey, don't make things worse.
Quincy, we talk about this.
All right, let's go inside and talk.
All right, let's go, Quincy. Go get on.
Let's go.
Come on. Come talk to your attorney, Quincy. Come on.
Quincy, we gotta go talk, all right? Next.
Quincy.
What we're gonna do next? Come on. Don't bet me on this.
Let's go. Come on.
Hey.
Quincy.
Quincy,
you're being recorded, so.
And you're not helping yourself out at all.
Careful what you say.
Yeah.
Go ahead and relax. Go ahead. I got my hands off you. Let's go. Come on, let's go. Come on, bud. I'm not touching you. I'm not pushing you. Come on.
Quincy Tuttle was sentenced to 2 years in a juvenile detention center. We're at the State of Connecticut Superior Court in Hartford for the arraignment of Isaiah Benitez, who is charged with first-degree murder with a weapon in connection with the passing of Felipe Lopez. The incident took place on Sigourney Street in Hartford on April 24, 2019, just 2 days before Lopez's 17th birthday. In addition to his trial for Lopez's murder, Benitez faced accusations of assault and attempted murder from an incident in March. When Benitez turned himself in 2 days after taking Lopez's life, he admitted to authorities that he fired at Felipe. He explained that he had sent a text message to someone asking to buy a dime, which is $10 worth of cannabis, at an address on Sigourney Street. When the supposed seller arrived, Benitez said he approached the passenger side window, which rolled down, and told the teenager in the driver's seat that he was there to buy cannabis. The teenager then grabbed his left arm, prompting Benitez to pull out a pistol with his right hand and fire 2 rounds at him. He was about to be sentenced by the judge after being found guilty of first-degree manslaughter when an unexpected turn of events occurred. Juan Felipe Lopez's father and his twin brother suddenly lunged at Isaiah Benitez.
On that file, and the other file, Your Honors, for interfering in an FTA second. He was given a promise to appear on that file. He has 1 conviction.
Court officers quickly subdued them and pulled Benitez out of the courtroom before chaos ensued. Juan Lopez's father was handcuffed by court marshals and escorted out of the courthouse. Thank you so much for watching. Don't forget to subscribe and hit the notification bell so you can stay updated with our latest videos.